alleged. However, you had to show another crime to show a pattern of racketeering activity, or you could not sustain your RICO charge. All right. So if you only show interstate commerce, you only got just that, you know, transportation of children for the purpose of sex. You don't have a RICO charge, which destroys your statute of limitations from. You have a statute of limitations process. All right. Now, so they had to have the money structuring charge to justify racketeering activity. You follow me? Because you got another crime. Right. Now, our argument before the appellate court was, look, you have an allegation of racketeer of money structuring, but there's no evidence whatsoever that even if the interstate transportation of minors was true, there was no profits made from it. There was nothing that links this alleged money structuring charge with the transport. Generally, in the organized crime situation, you have a house of prostitution, or and money was used. Profits from that were taken to put in the bank or not put it in the bank, or whatever you were doing. Money laundering, murder for hire, bank robbery. The organization were operating in several different crimes, which would be a pattern of racketeering activity. But the government in this case struggled to show the pattern of racketeering activity, so they were searching for another crime. You follow me? The two had nothing to do with each other, and we argued that. And it seems like the judges picked up on that, but I think at the appellate level, but I think at that point they were already pretty much like, we're not going to let this guy out. The government failed to prove when Richard Moultrie was asked what was the connection between the two, and he said none. Pretty much.
Yeah. And you know, and also too, the tragedy of this case also, if you look at the dates that these RICO offenses occurred, they were all in 1999. All right. Now that's the money structure. Okay. Now Dr. York been up here since 1993. I'm quite sure he was doing banking. All right. Before 1999, before the offenses. Let's assume that he started banking in 1993. Then that's, you talking about 6 years. All right. After the offense, the initial offenses. Initial offenses was 1993. So you're talking about 6 years. All of a sudden, RICO offenses. Okay. Now, all right. No one can argue that the RICO offenses was used to finance acts of molestation that happened in 1993. Okay. But that's what the court have concluded. All right, when they said that, you know, in order to join two offenses that by nature should have been misjoined. Okay, so you got a situation now where, and also you had testimony by Abigail, who was the chief witness against Dr. York for the prosecution, who testified that there were times that it was less or more than $10,000. Yeah, less or more than $10,000, and she was the one who was making the money. She was making the decisions. Okay, so that took the intent away from Dr. York and attached it to her. And the federal government still, all right, pursued it as though Dr. York was the one who was running the financial picture, and it was clear based on the government's own witness testimony that he wasn't running the picture.
Situation. Yes, I was in charge of the finances, and a lot of the financial decisions that were made were by me at the time that I was in charge. When I wasn't in charge, when it was Kathy that was in charge, the financial decisions were made by her. Malachi did not make financial decisions. We collected the money, we separated the money. When I was in charge of where the money went, how the money was handled, how it was separated. He never sat us down and told us to avoid the FBI or avoid the IRS or avoid doing anything illegal with his money. As a matter of fact, he was very, very serious about handling his finances in a legal way. So anything that happened with the finances, when I was in charge, it was my decision to decide what happened with the finances, where it went, and how it was handled. And the same goes for anybody else who was in charge. prior to me or after me. That's how it was done.
What we're saying is, if you're gonna bring both charges, separate them. Charge money instruction in one indictment, charge, interstate commerce in another. But by joining them, you justify the RICO. And that, it's still no evidence that the two were connected. I think that was admitted by the government at our arguments. And that's why we argue that point, and I still think it's a valid point.
See, what you gonna find in that Supreme Court decision, U.S. Circuit Court of Appeal decision, is that they stayed away from any issue that would have been looked at as favorable to Dr. York.
Right. They just said it was moot.
Yeah, they said it was a moot issue, okay, but they stayed away from that. Right. All right, and they told you clearly on the face of the decision that they looked at evidence in light most favorable to the government. All right, now to me, in that is a bias.
Right.
All right, because the courts are not supposed to operate on a faulty presumption. All right, okay, but when they do this, they operate on the presumption that A, the government is always right, B, there's no criminals in government, and C, government officials are only doing their job. All right, and I think that's in itself a detriment to a presumption of innocence in a criminal matter.
So the next day, Jacob